morning's docket. Case number 109912, State of Kansas v. Gray.
May it please the court. I'm Carl Maughan. I represent Kevin Gray, the appellant in this case. Your Honor, I'd like to reserve 5 minutes for rebuttal.
5 minutes is granted.
Thank you, Your Honor. Your Honor, what we're asking for today is that this case be remanded to the district court for a hearing in accordance with KSA 22-3504. I recognize that there's a long line of precedents from this court and from the Court of Appeals that grants the district court the right to preliminary review of the pleadings and summarily deny the motions if there is no significant issue of fact of law. However, I am respectfully suggesting that when the plain language of the statute and of the legislation specifically lays out a procedure by which a certain type of motion is to be resolved, the court ought to follow that procedure. And as such, Judge, I'm asking the court to, or inviting the court to reconsider the line of precedent, namely under Duke, but obviously there's several other cases as well. The summary dismissal rule in such situations, if the legislature wanted the district court to have the power to summarily dismiss a motion, the legislature would have inserted that right or that grant into the statute. It's a fundamental principle of law that a statute will be given the effect intended by the legislature, and that intent is generally reflected in the plain and unambiguous language of the statute. In this case, the plain language of the statute was that the defendant shall be given a hearing at which he can be present along with counsel. That plain language was not given effect in this case. The case was simply dismissed. I'm asking, based on that the case be remanded with the defendant can have a hearing in accordance with the statute. Even though there is precedent against me on this, there is also precedent, as I said, talking about how we interpret legislature and how we give effect to legislature. The summary dismissal rule is a judicially created rule that is not entertained by the legislature or the statute. And as such, I would ask that the court reconsider that. But even if we do follow the summary denial rule, I would suggest that the court here erred in summarily dismissing this case because there are significant issues of law that were raised.
Mr. Maughan, are we
Yes.
treating this as a motion for a legal sentence? Or what's the procedural vehicle?
My understanding, if I'm remembering correctly, that the statute was not named motion to correct a legal sentence.
It was a motion to correct journal
The journal
entry.
entry.
Right, but
However, there was a subsequent motion that was filed that was entitled Motion to Correct a Legal Sentence. And so I was asking the court to construe the pleading liberally in order to interpret it as a motion to correct the illegal sentence. Because,
and how is this an illegal sentence?
well, and that gets to the crux of it, is that before we dismiss the case summarily at the district court level,
Well, let me ask my question. I'm just real elemental. Our definition of an illegal sentence has 3 different types of sentence.
Okay.
Which of those are you relying on?
I'm relying on the vague and ambiguous sentence under the statute.
But that isn't just vague and ambiguous. It's more specific than that as to vagueness as to the time and the manner to be served.
Right.
And isn't it pretty clear here what the time of sentence is and the manner to be served?
The total time was certainly very clear, and the manner and meaning in Department of Corrections was also very clear. But the time and manner as to each count and as each crime of conviction, so which crime was being sentenced to a certain amount of time, That was what the defendant was arguing was ambiguous. And Judge, I think by getting into that at this hearing, at a Supreme Court level, I think we're getting ahead of ourselves. The fact is that the point of the district court hearing would be so that the defendant, along with an attorney who could sit down with him, get some understanding of what it is that he's trying to convey, and then make those arguments to the district court. By deciding now that this may not have been an illegal sentence, when the defendant has never had the chance to have a hearing at a district court level with the assistance of counsel as contemplated by the statute, we're kind of getting ahead of ourselves, because a pro se defendant, when trying to convey his idea of why the sentence is illegal on paper, may not be doing it very artfully and may not be putting forward the arguments that may actually be meritorious. And so that's why he gets an attorney, so that we can sit down to talk with him, try to figure out exactly what it is that he's trying to convey, and decide at that point, okay, I see where you're going, but this isn't the argument. So when I argue to you today, I'm looking entirely at just his pleadings and what he was asking for in the pleadings. And it's difficult to do that because without having a potentially evidentiary hearing as to, okay, what was said, what advice was given, let's look at yes, the transcripts could be evidence, and I know they speak for themselves, but introducing that and parsing that out at the time. And so I think we get ahead of ourselves if we ask now, was this an illegal sentence? Why is it illegal? Because what I'm arguing for is the opportunity for the defendant to have the hearing at the time, at the district court level with the assistance of counsel. He may not win at the district court level, but he does get the hearing. And so when you raise the issue, this is illegal because it's ambiguous or vague, or even, as he did lay out in some other pleadings, because he wasn't given the proper right to present evidence and mitigation. And I know I didn't brief that wasn't the point I laid out in my brief. But in preparing for this argument, I did see that there were some other pleadings there that suggested that as well. But those are significant issues of law. Was my sentence ambiguous? Was it vague? And why was it vague and was it ambiguous? It's a significant issue of law. And then we go back to the statute and say, the statute says he gets a hearing with counsel and a right to be present. Even if we follow the summary dismissal rule, he raised a significant issue of law, and therefore he should get the hearing. And so on those grounds, Your Honors, I would ask that this case be remanded back to the district court. We have two competing lines of precedent here. One that says interpret the statute as it's written. The other one says the district court gets a right to summarily dismiss the case if they don't believe there's significant issues of fact of law. I would ask the court to interpret the statute as it's written and give the defendant the right the legislature obviously intended him to have. And so I'd ask this case be remanded to the district court for a hearing on the motion to correct a legal sentence. Unless there's any other questions, I have no further arguments.
More questions? Thank you, counsel.
May it please the court and counsel, Assistant District Attorney Matt Maloney for the state. With respect to the first portion of the defendant's argument, the state would just ask the court to adhere to its previous holdings in Duke and the numerous cases that have followed. This court has read the statute and interpreted it correctly, and our position is that that should remain good law and that the defendant is not entitled to a hearing in the appointment of counsel simply by virtue of filing a motion to correct an illegal sentence. Turning to the merits, the written motion in this case, the defendant argued that his sentence was illegal because the journal entry failed to do certain things. With respect to that argument, First of all, the state's position is that a sentence is effective when pronounced from the bench, and that anything that happens or that is included in the journal entry has no bearing on whether a sentence is legal or illegal. Secondly, our position is that in this particular case, the journal entry does not contain any errors. So either on the merits or just as a general proposition, the defendant's claim cannot afford him relief. Finally, in cases in which there might be an error in the journal entry, the remedy would simply be to draft a nunc-pro-tunc, and the case law is clear that that does not require the defendant's presence or the appointment of counsel. In his brief, the defendant for the first time also made an argument with respect to what happened at the sentencing hearing. He did not, however, argue an exception as to why that claim should be raised for the first time on appeal. So our position is that because it was raised for the first time without invoking an exception, that issue should not be addressed on its merits. Alternatively, our argument is that the court did not impose an illegal sentence, that this was not an ambiguous sentence with respect to the time and manner in which it was to be served. The court specifically stated the sentence on each of the individual accounts, and the court did at the outset of the sentencing hearing note which counts he had been convicted of, which counts he was being sentenced on, and early in the sentencing hearing did specify that count 6 was the attempted rape count, and the court had already indicated that the other counts were rape counts. So nothing that happened at the sentencing hearing created an illegal sentence. So even if the court were to reach the merits of that argument, they do not entitle the defendant to relief. If there are no questions from the court, our position is that the district court made the correct ruling in denying this motion summarily, and we would ask that that decision be affirmed.
Any questions? Thank you, counsel. You reserve 5 minutes for rebuttal.
May it please the court, unless there are further questions, I would stand on my previous arguments and simply ask that the case be remanded to the district court for a hearing on the motion to correct a legal sentence.
Seeing no further questions, thank you, counsel. Well, thank you both for your arguments this morning. The court will take this matter under advisement. This time,